Over.
Item number 1.
Just a minute. Item number 4. CD is not received. Issue reminder for the CD. Interim extended. List on. Oh, interim is not there. I see. No issues. Issue reminder for the updated case diary. Full stop. Is the matter on? When should I fix? Monday? Okay. Monday. It's okay, no? Okay. No, there's no interim actually. Today is Tuesday, no? It will come. It'll come. 16. It can come. Yes. 16, yeah. Yes, ma'am. Yes.
Number 1.
Okay. Oh, I see. Just a minute. Never mind. So we'll see it again. It's a subsequent bail application. Like this. Stuck. What's at that case, no assault. Anyway, the earlier bail application was rejected on 4/2/2026 as fairly submitted by the learned counsel in BA B27 27 of 26. Full stop. Call for the updated case diary of from the concerned police station. This was a BA, right? He's in custody since 3/12. I see. Nice. Short date within this week. Huh? No, it can be, but I am ready if it can be on Friday also. When do you want it, madam? Monday, it's okay for you. 16.
Item number 2.
Someone from the other side? No, nobody is there from the other side. We had heard, no, this partly this matter. She's a just a minute, I'll come to DV. I'll come to that. Where is the impugn order? Let's see the impugn order. There should have been a note there actually. Not here. Anyway. But one problem is that who is the other side? Mr. Biswas had appeared. Just a minute. 17/12/24. Can you come to? Do you have the You won't have this. 1712, there's an order. Huh? You may not have it. 1712-24. Okay. In that order, it is written that an appeal, 29 appeal is pending. It's already been. In that case. Mhm. Mhm. Okay. Mhm. Mhm. No, against the interim order, which is the impugn order here, no appeal is pending. Yes. So this is a wrong submission. That means. Copy of the order. Yes. Yes. Yeah, 17/12/24. But thereafter not filed. According to you, it's not filed. Appeal is not pending. Okay, as per your instruction, appeal is not pending, right? So anyway. Yes, yes. H. Just hold on. I just have a look at. See, otherwise, we'll proceed. But as far as I know, the criminal petition caution it is maintainable against DV, initiation of DV or whatever. But if an order is sought to be, if someone wants to challenge an order passed in a DV proceeding, then 29 usually applies. So we'll have to tackle that question. No? Okay. Let us read the order first.
Section 24 says that a free copy of the order, any order maintenance has to be furnished to the parties of the application. And section 29 says the 30 days from the date of the service of the order.
Mhm.
That is when the free copy is furnished to the parties, that the party is meaning that the respondent of the DB case. That when I receive the order from that date, that date is the time.
Anyway, let us first read the order. We'll take a call on that issue also. But
the accused person says is the accused person is notified to the respondent in the Northern Maryland that their marriage was solemnized on 7/5/1998, and from the word of one female child was born on 24/4/2003. That from the very initial stage of her conjugal living, she witnesses a very unhealthy and uncomfortable nature and behavior of the husband. Respondent who most of time interacted with her in very crude and harsh manner and used to insult and humiliate her in very small and quickly matter concerning their day-to-day regular family life. The respondent husband started torturing domestic violence to her both physically and mentally, and also demanded very return in the form of money to be brought from her paternal home. He also briefly neglected and refused to provide the basic needs and proper food of clothing. That her husband responded to domestic violence regularly upon her since marriage, her husband willfully not maintaining her and her children. The light of the above mentioned facts, the contents of the party has prayed for one living. I have therefore gone through the case record, also perused the relevant documents before this report. I granted counseling at length for the accused person. persons have also filed assets and liabilities affidavit as per direction of the court. There is the same, there is the objection, written objection submitted by the respondent. It appears that Deep is a yoga teacher at the Delhi Public School. Gauhati, the respondent side has also filed assets and liabilities affidavit. And this figure, let us now peruse the view taken by the Honorable High Court, Honorable Delhi High Court in Bharat Service Sarup reported in 2007 SSC online Delhi 6/2007 laid down the following factors to be considered for determining maintenance: the status of the parties, reasonable warrant of the claim, independent income of the property and payment, the number of persons and non-applicant has to be maintained. The amount should aid the applicant to receive the lifestyle as he or she enjoyed the matrimonial home. Non-applicant's liabilities provides food, clothing, shelter, education, medical attendance, treatment, etc. of the applicant. Payment capacity of the non-applicant. Some guesswork is not ruled out for estimating the income of non-applicant when all the sources, correct the sources are not disclosed. The amount awarded, this line is important. The amount awarded under section 125 CRTC is adjusted against the amount awarded under section 24.
Yes.
Of the Act. Now this part is operating the directed Now the observation of this honorable court is that the non-applicant is also entitled for maintenance. Well, the non-applicant adult child also entitled when the proceeding is conducted under 1 to 5 of the CRPC. And my case is a DB. But the DB case only stands in a different form. It is not for the maintenance, it is for the monetary relief as specifically stated in the section 20 of the DB Act, which says that if there is a damage, if there is a loss of earning, if there is a displacement from the home or flat, under that circumstances they are entitled. So, and the DB Act also says that every person can have children, and the children is defined by the A in the section 2. The children is person who is below 18 years. So this is not idea of the also I made it clear. The children again I made it clear that being the father of my daughter, it is not an issue to maintain herself. I'm always ready. In fact, I'm also providing her educational expenditure. My issue is that the judicial order is not maintainable, that I should deposit the amount in the hand of the agreed wife in the name of my
Yes,
daughter.
I'm remembering now. Yes, you want to pay directly to her.
That amount, it's I'm paying 20,000, it's recorded. But I pay the amount directly to the accounts of my daughter. She is a student. Earlier she was studying there in the Bangalore. Now she has got admission in the alia program in the Gauhati. And she is in continuous touch with me also. Whenever she needs anything.
You want to pay a comfortable amount informally. That means according to you, she's the daughter. Your daughter is not liable to get under DB Act.
Yes.
You want to pay informally and directly to her.
Yeah.
That is the point. Let us see the definition once, because we should keep brushing. Child means any person below 18 years and includes any adopted step or section 2B. She is a major, Sudesh.
But on 24/4/2003, it is about 20 years right now. When the order will pass.
I see. Let us see the 20, section 20. There's another thing, to meet the expenses incurred and losses suffered by the aggrieved person and any child of the aggrieved person as a result of the domestic violence. Okay.
Lordship, one thing, Lordship, I take note of this, my submission, that when the aggrieved person is entitled for any compensation or monetary relief, there is a law providing, there is a medical exception. The law goes into the destruction, damage, or removal of any property from the control of the aggrieved person. These are the criteria. Constitution taking note of this criteria. The learned trial magistrate shall avoid compensations for either party in the order maintained.
You had filed an additional affidavit. Got your point. But let us also go into this because we have to negotiate this issue also, right? 29 appeal. Because there's a statutory remedy, right? Thereafter, usually come there. After 29, they come to the High Court usually. Deponent reserve. I am on your additional affidavit. Martin. There is no provision of delay condonation in DB. I've forgotten actually. I have to refresh. In the Act, there is nothing. So whether 29(2) will apply, Remittition Act. 29(2). Act is silent. Huh? No, there must be some case law. I'm not recollecting at the moment. There must be some case law. So it was not accepted because it was found to be, it was said to be beyond the period of limitation. Uh-huh. Mm-hmm.
I had approached the court.
Date on which order meant by served on the aggrieved person, all the respondent. Date of serving of the order. From there, 30 days. Mm.
I had filed the appeal under section 29. Then, find a reporter also called from the
Is it? So that is in that backdrop, this has been filed. Report. Yes. No, it is pending. This, no, they in the report they're saying. No, they accordingly on the next day you read. Kindly come to the report. Kindly, you don't have.
The first order of maintainability that I have filed, that is accepted. And that is disposed also.
No, criminal appeals 65 of 24. What is this then?
While challenging the order, another order.
No. That's sort of confused state of affairs slightly. 22/4/2024.
22/4/2020. Yes, it is the order.
What is the 21/5 order? We are reading the 22/4 order. Where is the 21/5 order?
21/5 order, that was challenged also.
No, what was the 21/5 order?
Order, by this order, the landed plan of the rejected by.
Record is there. Scan record is there. No. Tell me clearly. What is the 22/4 order? Is the order granting maintenance?
Yeah.
Granting maintenance to wife and child.
Yeah.
And 21/5 of what is this order?
This order consider duty background of the order. I had filed an application challenging the maintainability of the duty proceedings.
Okay. Mhm.
The petition was dismissed by this order. 21/5.
By the court below.
Then I had filed an appeal under section 29 challenging this particular order. In fact, two different appeals filed. One accepted,
Dismissing the maintainability.
one accepted and one refused to entertain on the government.
Dismissing the maintainability. Against that, you have preferred an appeal which has been accepted. And this criminal appeal is that criminal appeal, that proceeding. Criminal appeal 65 of 2024, right? And against the interim maintenance delay. Okay. So you file this. But the additional affidavit also mentions impugn orders 22/4/24 and 21/5/24. You're challenging 21 the order 21/5/24 also you're challenging here actually. As per the additional affidavit, which has come after the main petition, right? It has come after the main petition. Which is confused actually. Here you are mentioning 22/4. But in the additional affidavit, you are mentioning 21/5. And against that, an appeal is pending. And a cost title. Anyway, I'll have to go through it probably. But can we won't we need the records? Or we can manage without the records. No, we'll call for it then. Actually, we don't take up the hearing without the record if it is necessary. Hmm? Yes. cost settled.
Initially, I had finished it all. But when they reduced the entertain the orders, it is 2020.
Mm.
It was quite slow. Then I
Mm.
took a different order. Initially, put the order to the challenge in the civil act.
Mm. Anyway.
Put off confinement,
Mm.
that the crime judgment we are giving to continues to allow the ability to advocate in the order itself. And you see about because out of my love and affection and voluntary contribution,
No, it will require interference with this order. You are, otherwise, in terms of this order, you have to deposit to her, right? To the daughter. Mm. We are also on the issue of maintainability, whether in the face of an appeal, if the appeal is barred by limitation and there is no provision for condonation, can we bypass that by entertaining a criminal petition? This also has to be seen, right? Should we close it or should we wait for the record? Because it's also pending. Let me do one thing. Let me close the hearing. You have completed, right? You have completed your submissions. So let me close it. He's not appeared. Several dates, not appeared on earlier occasion also. They have abandoned it. What I can do is I can close it. Let me see if I can dispose it of. If I have some difficulty, then I have to list it again for to be spoken to as a to be spoken to. But I may be able to, because first I have to see this maintainability issue, right? And limitation, there is no limitation period. Section 5 is not applicable. Because that is the general principle, 29(2) will be applicable. But if it is considered to be, the principle is like this. If the DV Act is a complete code in itself, laying down a period of limitation, then 29(2) will not be applicable. And if it is not a complete code, then 29(2) of the Limitation Act, it will be applicable, in which case, if limitation is not provided elsewhere, it will be 3 years. So there must be some case laws on this point. Surely it has arisen. Our High Court only, there might be some decision. From the date of, so that is also there. That is there. That is there. That's Matijo. Right. Hmm. Hmm.
Before the lordship that I shall not deposit the amount in the hand of the active. Why? Because the order.
Even I get your point, but suppose we uphold this order and modify it to say that you will deposit directly into the account. That will satisfy you. But the thing is that if the order was wrong because she is a major, then also it cannot be upheld. So all the things have to be seen, including limitation period. That's why let me go through it. And let me go through it. If I need anything, I will list it again.
Another aspect is and you get the maintenance flow for any law. It is not designed to punish the mistake. Basically, it is designed to prevent the definition of the prohibition. Why I educated earning huge amount of money, and there is no loss of earning, there is no penalty. Now the question of preventing maintenance income.
There is another aspect actually which I have not noticed from the order. I think if I am not wrong, I think interim maintenance in a DV proceeding under 23, I think section 23 probably. It requires an affidavit, right? Was the affidavit submitted before the? No affidavit. No, not affidavit of Rajneesh versus Neha. Then there's an affidavit is required because interim maintenance is granted only on the submission of the petitioner, agree person. So she has to submit an affidavit. Just let me refresh. 23(1), I think, subsection 23(1). Just see. 23(1). Ex parte and interim orders. Yes, affidavit is necessary. 23(2). Such form, so and so, so and so. Was there an affidavit? There in with regard to interim order affidavit, there is case law of our High Court only, and that affidavit is essential. Yes, number 24. No, commissions can you record for him? Okay. No, this is the affidavit. This is the assets and liabilities affidavit. 24. Oh, also 34. Apparently, though. And while passing an interim order by the magistrate, since this is a statutory requirement, the magistrate also has to mention about the affidavit. That affidavit in terms of section 23(2) has been filed. I peruse the same, and that has to be, because it is given on what has been stated by the petitioner, right? The aggrieved person. That is why it is necessary. Anyway. Mm-hmm. 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 Disposed, appeal is pending. Appeal is also dismissed. Yes. Maintainability. Okay. Okay. DV, actually criminal appeal is a misnomer actually. DV is actually family court stuff. But since it's from magistrate, it becomes criminal appeal. Anyway, only one provision of DV, you criminal, if the protection order is violated, then it becomes a criminal offense. 30, I think. Except that it's a civil. Anyway, so let me reserve it. Mr. Mazumdar, FZ Mazumdar, Learned Counsel for the petitioner. None appears for the respondent today. The last few occasions also, none had appeared on behalf of the respondent. The Learned Counsel for the petitioner had addressed arguments on the earlier occasion, and the matter has remained as part heard. Therefore, I proceed to complete the hearing in the matter. Full stop. Mr. Majumdar, Learned Counsel contends that the petition, the Learned Court below, by the impugn order dated 22/4/2024, was pleased to grant maintenance not only to the aggrieved person / wife, but also rupees 4,000 to his daughter, further containing that 5,000 to the daughter, further containing that though he has no disagreement about paying money to the daughter, but such an order under the provisions of the DV Act cannot be passed as the daughter happens to be a major. In this context, it is submitted that section 2B of the DV Act defines a child as a person below 18 years, and section 20 pertaining to monetary compensation for domestic violence provides for granting maintenance to the aggrieved person and her children. It is submitted that the petitioner is already paying financial support to his daughter and is willing to do so, but he desires to pay the amount directly to his daughter instead of to the respondent aggrieved person, instead of through the respondent aggrieved person in terms of the impugned order. With regard to the applicability of section 19, it is submitted that that an appeal against the order dated 22/4/2024 was sought to be preferred, but it was not accepted on the ground of having been filed after the period of limitation prescribed in section 29. Full stop. It is submitted that the that section 29 provides a limitation period of 30 days from the date of service of the order, date of service of the order upon the respondent, and by that calculation, there was no delay. Full stop. It is submitted that the petitioner had also challenged the maintainability of the DV proceeding, which was rejected on 21/5/2024, against whom he preferred an appeal numbered as criminal appeal number 65 of 2024, I think, 24, and the same also came to be dismissed. Yes, it's written here, full stop. It is submitted that as his appeal against the order dated 22/4/24 was was incorrectly not accepted on the ground of limitation, he has invoked the inherent powers of this court. Summing up his submissions, the learned counsel for the petitioner seeks interference with the impugned order passed by the learned court below, learned JMFC. These are submissions. Otherwise, you heard judgment order reserved. Please tag it. Anything else?
Number three.
This matter you had placed something, no? No, this judgment is actually, it has been overruled. That has been overruled actually. Rajdev Sharma had laid down a law that is. That is true. That is true, but only on the ground of if it is beyond 3 years, prosecution evidence is continuing beyond 3 years. That was laid down, but it was set aside in which judgment? That it was set aside in which judgment? I think prosecution. Yes. We can give a direction, they'll speed up the trial and complete, right? They'll complete. We have to go by the law, right? I was also surprised that I don't know whether automatically will it end, but it was laid down, but it was a challenged and constitution bench. Constitution bench. Page. See, these things actually, it was done, probably done in good spirit, but this will create practical difficulties sometimes. So that is why. Hmm. $256. Okay. Yes, I remember now. Actually, the magistrate said that it's a warrant case, so 256 not applicable. 256 not applicable. Okay, I'll go through it. Mr. Loskar. That's it. Miss, no problem. Yes. No time also. Reserve it. Huh? Time, yes. Don't worry. If it's everybody has a right actually, but because you have to divide. Why? There's another matter. Why? I didn't know. Could have taken the bail before. I didn't realize there was another matter actually. There's no time also now. I would have taken the bail before this actually. I thought bails are over, so I would have taken the bail before this matter actually. Would you like the matter to be tomorrow? Because tomorrow only one matter is showing in my cause list. We have we have a couple of hearings and the division bench. I don't know how many will reach, but mostly admission and orders. So tomorrow in my list only one matter is, so we can do it comfortably tomorrow, right? Paucity of time tomorrow. The case, the scan copy is available.